a natural person in full life, in propria persona, sui juris inheritis, my nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire.
Sir, you've been speaking for 30 minutes, repeating the same things many times. At this point in time, we've come here. This is the 6th time we've been here. I deny all of your myriad of arguments as...
Right out of the gate, we're hearing arguments commonly associated with the sovereign citizen or Moorish national movement. Courts hear these claims fairly often, but here's the important part. Simply declaring a different legal status does not automatically remove a court's jurisdiction. Watch how the judge responds. Do you think the judge should let him fully explain or cut straight to the legal issues? Let me know in the comments.
I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you 1 second. I need to look over some things. Are you representing yourself?
No, sir, I'm not representing myself. I'm presenting myself.
Okay. I mean, do you have is a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Okay, calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell me
my
your
name.
Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person for life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk, but I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need
Okay. Are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm in a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witnesses. Personally appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or abusing any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond? What I've read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So, what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Campbell. I'm a natural person in full life, in propria persona, sui juris or habitus, my nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire. I come at Northwestern Exum, at North America, North Gate, Turtle Island. I come under protection by way of Treaty of Peace and Friendship, 1836, between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Kemp Hill in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also reside in domicile at. That's my address. That's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there, and so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one.
This is a critical legal moment. Even when someone chooses to represent themselves, the judge still has a duty to explain the charges, enter a plea if necessary, and set bond conditions. The courtroom isn't debating political philosophy here, it's making sure the criminal process moves forward according to law.
One time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back to that location. You have another court date coming up. Your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like one more thing, sir. I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned, also. So.
Okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the biometric fingerprint data prior.
Good afternoon. The 14B District Court is now in session. My name is Uraine Washington, and I'm the judge that will be presiding over this session. The court will call the case of Country Meadows Apartments versus Tariq Day and Erica Witherspoon. Case number 23C0276.
Good afternoon, Your Honor. Christopher Borkin appearing on behalf of the plaintiff.
Good afternoon.
Hello?
Hello, we can hear you, Mr. Day. Please state your name. Can you please state your name, sir?
You hear me?
Yes, please state your name.
Hello?
Can you hear me, Mr. Day?
I was going to respectfully request it. Was there...
Can we please
escrow-
let him say his name first?
Yes, absolutely.
Mr. Day,
Yes.
Could you state your name, please, sir?
I am Teresa Martari Day.
Thank you, sir. All right.
Your Honor, was there escrow ordered in this case?
No, there's no escrow that's been ordered.
Understood. I think there was some confusion on my part early on. Plaintiff respectfully requests the court to find no triable issue today. Rent to retain is $4,323.60.
Mr. Borkin,
Yes, Your Honor.
I'm going to need you to address the issues that we left off with before we get to that, which
Absolutely.
was the fact that at the last time we were here, there was a Ypsilanti Township property code violation notice that was posted, and we didn't know the details of that or the status of that.
Yes, Your Honor. I did investigate that further between last hearing and today. There were two items that the city requested fixing in Mr. Day's apartment. One was a gash in the kitchen floor. They requested that be fixed or replaced because it was a tripping hazard. And the second item was a gap between the window and the windowsill, or somewhere in the window or window frame. They requested those two items to be addressed. They have been addressed, Your Honor. The floor was replaced on the 4th of April, and the gap in the windows was fixed today. The reinspection was today, Your Honor, and the city inspector did indicate that the problems were addressed, that there were no further actions to be taken by my client.
Thank you. Mr. Day, is that true?
Are we addressing the my claim
Day,
for the
Mr. Day, could you please answer the question about whether that is true or not?
the floors were fixed, but the windows were not. But aside from that, I was needed to know because we didn't ever address the issue of the violation of my consumer rights.
Your Honor, the city did indicate that the windows were fixed to a satisfactory point where they requested no further action be taken.
Okay.
May I speak or whenever you're allow? I can wait.
Thank you, sir. Mr. Morgan, you may proceed.
I'm sorry, Your Honor. I was closing my door. Could Mr. Day repeat the last thing he said?
Mr. Day, he
wait.
said he could wait later to talk, is what he said. He wants this opportunity to speak. That's all he was saying.
Understood. Thank you, Your Honor. May I proceed with the facts of the rental arrearage?
You may.
Rent to retain is $4,323.60. Court costs are $158, totaling $4,881.60. Plaintiff respectfully requests the court to find no triable issue today.
Thank you. Mr. Day, your turn.
I would like to address the violation of my consumer rights. I wasn't given full disclosure. The primary violations are. Sorry, I wrote them down. I'm sorry. There they are. The primary one was the right to consumer education, as well as the right to be informed, which also alludes to my right to choose. I wasn't given full disclosure upon all the information of the contract. I was not told about my right to the education of the consumer transaction that was going to be taking place. I wasn't told that as of the consumer credit transaction that took place, or the consumer purchase that took place, that I was in fact the creditor of that account, because with our private property being the signature, it was given the contract. It gave the contract interest, and we became investors within the trust agreement of between Country Meadows Apartments LLC and the natural persons, consumers on the contract. And I would like the opportunity to be able to effectively perform our defense in regards to the claim that was sent to you all as well. Yes. So with that all being said, I would just ask for a date to be able to provide my defense and all my evidences.
Today is the date for any defenses and evidences, Mr. Day.
That's I was not told that. All you said about this meeting was that we'll be speaking on the corrections of the uh, township document or inspection. I was told that this was going to be a date for me to be able to provide my defense. Yeah, that was never talked about. And when I did try to speak, I was kind of bombarded, and I was under a sense of duress. And I'm just asking for a proper date for me to be able to provide my defense, as is I am allowed through the consumer bill of rights, which I have the right to be heard efficiently and without any kind of um, forced action because of a lack of communication and transparency. I was not told. I don't know if I know it's not on the record because I went back and I watched the uh, recording on YouTube. It was not stated that this is going to be a day for me to provide my defense. So if that is what's being said, then again, that'd be a violation of my Fourth Amendment right, as far as the United States Constitution goes, and as well as what I already mentioned of my consumer right of having the right to be heard.
All right. Anything else you want to present today, sir? Because today is the hearing.
That's the whole point. I was not given. I wasn't told that this was going to be a date, so I was not. Wasn't allowed the proper time to have all my evidences present so I could put them on the record.
All right. Thank you, sir. Anything else, Mr. Walker?
Your Honor, from what I gather from Mr. Day's statements, there are certain things that seem to refer to the motion that this court already ruled on. I will not address those. There do seem to be things along the lines of what Mr. Day was told in terms of his rights as a person signing a lease in Michigan. I will indicate for the record that my client's lease has all the proper disclosures under Michigan law to Mr. Day. Mr. Day did, in fact, sign his name to that lease agreement. And I would again ask the court to find no merit to those arguments and no triable issue. There is this other issue that I can gather with there being a trust agreement and Mr. Day being an investor of the property under that trust agreement. Your Honor, I've seen no evidence to support this claim, and if there is any merit to this claim, it has nothing to do with the possession judgment plaintiff is requesting today. Thank you.
Now the conversation shifts into treaties, corporate entities, and living man theories. These arguments are popular online, but they're almost never accepted as a defense in criminal court. Judges focus on statutes, evidence, and binding precedent, not internet legal theories. Have you ever seen one of these arguments actually succeed in court?
This court haven't heard no defense to the actual amounts that are being claimed at this time.
Objection.
Today, why are you interrupting me, sir?
You're stating that the court doesn't have any defenses or haven't heard any defenses from me, and I have the trust agreement, the equitable ownership of the property, as well as equitable ownership of this account, and I can provide the certificate of trust, which states that the property is within the trust and has been conveyed to the trust, and also that in regards to the the alleged amount owed, um, I can provide the fact that is a violation of, what is it, 15 USC 1692C, which states, sorry. Oh, yes. If a consumer notifies a debt collector, the debt collector would be um, uh, Country Meadows Apartments LLC, uh, that refused to pay the debt, or that the consumer wishes the debt collector to cease further communication with the consumer. The debt collector shall not communicate further with the consumer with respect to such debt, except to advise the consumer or the natural person that the debt collector's further efforts are being terminated. Two, to notify the consumer that the debt collector or creditor may invoke specified remedies, which are ordinarily invoked by such debt collector or creditor. And I am uh, uh, notifying the debt collector or Country Meadows Apartments that I am the creditor, and I am seeking, invoking, excuse me, my specified remedies to settle the matter at hand. Again, according to the alleged amount owed, I do not agree with that. And I can also provide the violations tied to that.
Violation, sir.
The first would be, I'm sorry, I'm trying to get it all together. As I stated, I wasn't given notice to have this all concise. You'll give me a brief moment. Well, one of them would be 15 USC, subsection 1692, E, which states a false character amount.
Notice the judge's response here. He doesn't argue every claim point by point. Instead, he tells the defendant to raise those issues before the trial judge. That's actually a common courtroom practice. Judges often keep hearings limited to the purpose they're scheduled for, instead of allowing them to spiral into unrelated legal debates.
Or legal status of any debt, also known as, if the amount shown is positive, it is false and misrepresentation. If the balance was owed in a bank account, it will be shown in the negative. This amount is shown positively, which makes that the person makes it so how can a person pay on a positive amount unless there's a double or the T ledger bookkeeping being presented, which again goes to my violation of my consumer rights of not having full disclosure. I wasn't told that there will be a T ledger accounting being performed, to whereas the positive balance that's shown that I received from the assistant, Stephanie Robust, I believe this was last month, so it didn't have the alleged incurred or additional amount that brings it to the alleged 4,800 or whatever. The price in that she gave me was, as of March 6, 2023, was $3,700. And as stated in 15 USC 1692, if the balance were to be viewed in a bank account, it would be negative. So if I were to receive a correspondence from or a bill from Country Meadows Apartments, it would have that the alleged balance owed would be a positive balance and not a negative balance, which again is a misrepresentation of material information. So, as I stated, I would just truly appreciate an opportunity to get all my defense together properly. You stated this was going to be uh, a continuation to the matters of the uh, township violations. And again, I was not given proper insight or I'm sorry, the term leaves my mind, but I wasn't given proper notice to have um, my defense prepared. Also, to the point of Mr. Borkin saying, excuse me, that the um, contract or the lease is up to Michigan standards. There were a few violations of the Truth in Lending Act and the Landlord Tenant Act of Michigan within that lease. One being, I'm trying to remember off the top of my head because I don't have it in front of me. But one in particular was a waiver of uh, trial by jury, or which um, is a which is a not a priority, but it is I guess a precedent, for lack of a better term, of a right that cannot be waived. Uh, or cannot even be pushed into a lease agreement because it's a violation of the landlord tenant relationship act of Michigan. Um, Also, to the point of it talks about um, oh yes, to the point of the accounting, the misleading representation of the accounting matter on behalf of Country Meadows Apartments LLC, to have everything be verified to the fact that um, the amount owed, the alleged amount owed, is covered.
Now we've switched from a criminal courtroom to a landlord-tenant dispute, but the pattern feels familiar. Instead of challenging the rent amount or presenting evidence about the lease, the defense pivots toward consumer rights, trusts, and creditor theories. The question is, will those arguments actually address what the court needs to decide today?
Via the obligation of the United States, which I believe is 18 USC 8, that states that all obligations are handled, for lack of a better term, by the United States. Since I am the first in line creditor, since the United States is bankrupt and insolvent, all credit is issued via consumers, and as I stated earlier, without my without the uncontracted use of my private property, which would be my signature, which Country Meadows then used to, excuse me, to invest within itself without uh, giving um, the uh, the ability to accept the interests that were incurred from the uh, investment uh, of the initial investment, and to have a solid view of what I'm speaking on, I will request a securitization audit to prove that the instrument or the promissory note was not securitized, which, if proven, it would show that securitization is a voluntary act of destruction, and which would mean that the contract was discharged. Yes. So again, I'll requesting along with the securitization audit of the account, requesting proper time to be able to further prepare my defense.
Here's the biggest takeaway from this entire video. Courts don't decide cases based on who has the most complicated legal theory. They decide them based on admissible evidence and laws that actually apply to the case. That's why preparation usually beats unconventional arguments every single time. What do you think? Was this defendant making a strategic mistake, or was the court too quick to dismiss his claims? Drop your thoughts below.